The Alien Claims Act. Alien Claims Act is a federal law of the United States of 1799, which grants jurisdiction to the federal courts to hear and decide on the merits of civil liable claims raised by foreigners in the face of the international law. ATCA is a jurisdictional statute. That means that ATCA doesn't create any substantive law because it's purely jurisdictional, authorizing lawsuits on certain special wrongful acts before the USA courts. The human rights cases they fall before the USA courts. They are civil lawsuits that suffer compensation for the lawsuits or claims. They are no criminal prosecution and will not result in prison for the accused. Historical evolution. Pre-Filartiga period, 1799 to 98. Because this law originated from an historical moment in which the international community was mainly concerned with regulating diplomatic relations between states and prohibiting crimes such as piracy. The first case brought before ATCA for human rights abuses was Filartilla versus Peñiral. In 1976, the father of a young man who had been tortured and killed in Paraguay while in police custody witnessed one of his sons tortured walking the street of Manhattan. The father called the ENC, who arrested the former Paraguayan officer for exceeding the visitor visa. And in 1980, in USA federal court confirmed his claim, opening the door for future claims under the Alien Tort Statute. The second period begins with the Filartilla case and runs until 2004 with the Sosa case, when a new stage opened and ATCA begins to be used in case of crimes of torture, genocide, or against humanity. The third period, where the court attributes responsibility to campaigns in the commission of international crimes. The fourth period, not yet concluded, is the one characterized by two judgments of Supreme Court related to the Kiobel and Daimler cases, in which a restrictive position of the High Court regarding the possibility of applying the ATCA to conducts that are developed abroad. According to the Sine Trainal case versus Coca-Cola in 2009, we have three elements: an alien or foreign, sues for a tort. The violation was committed under the law of nations. It is in this element that the importance of the ATCA in international law, because despite the fact that it was not initially conceived in this way. In the Sosa case, the court held that the ATCA grants jurisdiction to federal courts over claims based on specifically defining universally accepted and binding rules of international law. By establishing this norm, the court gave the green light to the use of the ATCA as a means of reparation for serious human rights violations. ATCA is often confused with the TVPA. For this reason, it is necessary to establish the difference between the Victims of Torture Protection and the Alien Tort Claims Act. They have the same intention, but the radical difference in who has the ability to invoke the TVPA is a United States national, not a foreigner. In the same way, in the TVPA, the legal entities can be condemned. What crimes are covered by ATCA? Torture, extrajudicial murder, enforced disappearance, crimes against humanity, state-sponsored sexual violence and rape, cruel, inhuman or degrading treatment, prolonged arbitrary detention, genocide, war crimes. Who can be held responsible? The respondent, a perpetual resident in the United States. The producer claims against an individual. That person must be directly or indirectly responsible for human rights violation and must be personally notified of the claim with the United States. In other words, the author must live or visit the United States.
official or a person acting under the law.
In order to sue for most violations, the abuse must have been committed by a government official or a member of the security forces, or by a person acting on behalf of or together with those authorities with them. Corporations. Suits can be brought against corporations those who are involved in human rights violations abroad, so long as the corporation has sufficient contact with the USA, acted together with a government entity or official, and had sufficient control over the violations. Head of State and Diplomats. The United States' current heads of state, president, kings, prime minister, foreign ministers, or officials with diplomatic immunity, cannot be held liable in a human rights claim. However, once they leave office, heads of state and other officials are subject to civil claims, even for human rights abuses that they committed while in office. USA government officials. ATCA cases filed against USA government officials. USA could front or legal challenges. Will ATCA lawsuits have been filed against USA officials for human rights violations, including torture and abuse of detainees in the context of the war or there. Courts have generally rejected such claims for a number of legal reasons. Several lawsuits have been dismissed under the doctrine of the political question and on grounds of sovereign immunity. In other cases, the United States government had appealed the privilege of state secrets. Under this legal doctrine, the government has traditionally been able to provide courts from hearing specific evidence that may threaten national security if it is made public. However, under the Bush administration, a broad interpretation of this privilege was invoked to summarily dismiss entire cases.